speaking on the application of MB and Secretary of State for the Home Office.
Good morning, my lord.
Good morning, Mr. Payne.
Can I firstly apologise for keeping you waiting?
Not a bit.
By mistake, I brought the submissions in case I did yesterday, which, although I'm sure you would have found fascinating, might
It would have been fun.
It is a lesson not to have all your files white. My lord, I appear on behalf of the Secretary of State, together with Mr. Briggs. My learned friend Miss Lawton, together with Miss Solanke, appears on behalf of the respondent.
Yes. Now, before we start, I'm sorry to have to mention this, but I don't know whether you've been aware that there were difficulties with the bundles in this case.
No, I wasn't.
Well, then, I'll tell you what happened. On Monday, I began to prepare for today's hearing, opened the bundles that had kindly been supplied. And the first thing that I found was that the core bundle in this case, the electronic version, had no bookmarks. And you'll appreciate that working with a bundle which has no bookmarks is practically impossible. So around lunchtime on Monday, my clerk communicated with Ms. Boyce, Government Legal Department, and conveyed a direction that the correct bundle bookmarked should be sent in by noon yesterday. We haven't heard from GLD since, as far as I'm aware. In consequence, my lady's clerk, who's just left, kindly spent an hour doing the work that should have been done by GLD. And consequently, I was then able to prepare for today's hearing. The other thing that I've noticed is that the authorities bundle in this case is defective because most of the authorities in it are not in the official report form. Presented with a heap of authorities like this, it's quite impossible for the court to gather what these cases are about or read them efficiently if one simply has the text of the judgments, as you well understand. Now, I'm saying this to you, Mr. Payne, appreciating that you didn't appear below, but you do appear on the appeal. The Secretary of State for the Home Department is, I would imagine, the most frequent litigant in this court. She and those who advise her ought to know how to prepare bundles properly. It's wasted time. It's caused a great deal of low-level annoyance as a result of this. I'd like a letter, please, by noon tomorrow from the responsible solicitor at the GLD explaining what happened in this case and what's going to happen in future to make sure it doesn't recur.
Yes,
I should add that yesterday afternoon, not having had any reply, my clerk communicated with your clerk and Mr. Biggs's clerk. Didn't get a response to that either, as far as I'm aware. So I'm not asking for any more information about that unless it's to correct what I've just said. But overall, not up to standard, and I don't think it can just pass unspoken. Having said that, unless there's anything you want to say at this stage, I'd just like to say it's got nothing whatever to do with the appeal and the matters which we're now going to consider. You can forget it for the moment.
Oh, can I just apologise? I certainly wasn't aware of any of these difficulties. Had I been, we would immediately have taken steps. I do sincerely, but absolutely. I mean, every single aspect of the criticism, in particular, the fact the Secretary of State is the most common.
Well, you'll appreciate if this was, if this was a local firm appearing for the first time in this court and they didn't know what the practice directions and the rules say, I wouldn't have taken this course. But if the court can't rely on the Secretary of State for the Home Department to, as appellant, to do it properly, I don't know where we've got to. All right.
As I said, Mother, I am genuinely sorry, and you will receive a letter by midday tomorrow.
Thank you.
So, my lord, in terms of this, the substantive appeal concerns really two issues. Firstly, whether the Upper Tribunal erred in concluding that the Secretary of State's certification of the respondent's claim for asylum under Section 94 was flawed. And the second is whether the Upper Tribunal erred in issuing a mandatory order requiring the Secretary of State to facilitate the respondent's return whilst this appeal was pending. I'll deal with the first issue, my lord, and Mr. Biggs will deal with the second issue in terms of the mandatory order.
Yes. So you're doing 1 and 2.
I am.
He's doing 3.
I am. Can I just say from the outset that it is accepted that in relation to ground 3, that the issue relating to the mandatory order may well in practice have become of little relevance. It seems to me that if you were to allow the appeal, then the order would automatically fall away. If you were to reject the appeal, the Secretary has already indicated that she will take all reasonable steps to facilitate the return of the respondent. That was recorded below, and that remains the Secretary of State's position. So, turning to the challenge to the Upper Tribunal's conclusion, I propose to advance my submissions under 5 headings. Firstly, I propose to deal with the evidence. Second, I will deal with the case law on sufficiency of protection, internal relocation, and certification. Third, I will deal with the case of TDT, which concerns risk of re-trafficking, and the case law relating to Albania. Fourth, I will take you through the certification decision, and last but not least, fifth, I will make my submissions in relation to the judgment, the Upper Tribunal's judgment. So, if I turn to the first heading, the evidence, can I ask you to take the supplemental bundle? I'll take you straight to the interview. Now, page 21. And I'm going to, obviously, I'm not going to read the whole interview, so, and I'm sure you've read it in its entirety, so obviously the points I'm taking are are selective, but they're the bits I wish to emphasise. So you have at 21, you have a background at the top of the family situation position in Tirana and Albania. And then at 21, you have the first reference or explanation as to the difficulties in relation to gambling. And then you have 23, you have the first reference to Arben, the man who initially arranged for the respondent to come to the UK. Then at 28, so the next page, so when I'm referring to the numbers, unless I say page, it's the boxes. So 28, there's a reference to the question is, have you ever thought of contacting the Albanian authorities? And the answer is, I thought about it, but no. And then the reference is, they are powerful people, so you would cause yourself more trouble. Now that can only be relate to Artur being the person who loaned the money, because as at the point of departure, as you'll see from the other responses, there was no issue with Arben. The issue that arose, or first became aware of a potential issue, was in Holland.
So Arben was the one who arranged the trafficking, the
That's
transport, right. And you say that it was only in Holland that there's somebody else who gets named, and that's when the trouble begins. That's
right, yeah. And I'll take you through the interview just to make that point good. Then the point is made at 29, that the police, this is the first comment of why I didn't go to the police. If I had money to pay the police, it would be different. So effectively the point is made that he didn't seek help because he didn't really have the money. to pay the police. And then the same part of paragraph 29, he says, I know what happened to other people who went to the police to seek help. And then at 30, where he's asked to explain what he means by that, you can see that it's just not so much people he knows personally, but just the generality, effectively inviting, relying on things like the news. And then the point is made, the question is asked at 31, how would Arthur and Arben specifically be able to stop you in obtaining protection from the authorities in Albania? And this is obviously one of the key answers. It is simply you would go to the police to report threats from individuals. These people would not go to prison, and next day things would get worse for yourself as they would know you'd reported them. And so that is the totality of the evidence in relation to why it is said by the respondent that he cannot access the police. It's either money to pay them or just this rather nebulous suggestion that things would get worse because of the two individuals. If we then look at 34, if we look at 32, that explains the point my lady, it's the start of the point that my lady was asking me about. If you read that paragraph, it's someone, Arben presents himself as someone who could get me in a job in the UK in a restaurant. I don't know if you know how it works in Albania. They have offices where you can go and they can get you work in places like Dubai and UK, other countries like that, with 1-year contract. So for that reason, I contacted him. And then at 34, the 5-6 lines down in terms of the answer, there's a sentence which says, and with Arben, I only realised it on the journey to get here. When I was in Holland, I realised they were involved in stuff that was not legal. 35 refers to them meeting them in Tirana. 36, why didn't you consider moving away, or have you ever considered moving away from Tirana? And the answer is to move where? Within the country. Albania is a small country and everyone's related to each other. It's only 2.5 to 3 million people. Wherever you go, people will ask about you and word will spread and they will find you. So that's the first reason he says he provides for not relocating. And then the question is asked, have you had contact with either man since arriving in the UK? The point is made, no. And then, importantly, have they been in touch with your family in Albania or here in the UK? Because, as you will see, when he's released from detention in the UK, he goes to live with his sister who's present in the UK. And so he says, well, by implication, it's no, because these people have issues with me and not my family. And then 42, it refers to the fact that the last time he had contact was 2 or 3 days. The last 2 or 3 days he was in Albania, to Arthur and Arben.
Was that 2023?
It is, yeah. So he arrived in England in August 23, so it's July, maybe beginning of August. And then at 45, it said, if you read the 5 bottom lines, it says, I told them this is not the job you promised me when they took me into that house, and I told them I didn't want to be there, and they spoke to someone in Albania, not sure who, and then they said, if you've got 25k to give us now, you can leave, but otherwise you'll have to work until the 31st of December 2023. Now, the relevance of that date is that the respondent was arrested in the UK on the 8th of December 2023. So whilst he hadn't quite completed the sort of 4 months from August to December, he had, on any view, he had completed the lion's share of what was expected of him. And then he's asked, how do you think either of these men would be able to find you if you went back to Albania? And he says, I'm sure it happened the first day I stepped in the airport. And then 48, have you considered relocating to another city? For example, Elbasan, Vlor, or Durrës? And again, the same point's made. No, because it's a small country. I've been thinking all of these months in prison, what would happen to me? I'm sure if I went back to Albania, I'd rather be re-trafficked, or worse, God forbid, would happen to me. And then he's asked again, 49, how would they find you in big cities? And he says, in Albania, these cities have 100k inhabitants. If a new person arrives, then he would be looked at with suspicion, and every neighborhood has people who are involved in crime to watch over these things. So there are 2 points, perhaps, or 2 points to note. First of all, the cities you're referring to are far bigger than 100,000. You just have to look at the objective evidence on that, and they are far larger. They're in the region of 200,000. The second point is that what he's saying is he is not saying at that stage that it is Arben's gang or people associated with Arben, or that Arben has influence that extends to these cities. It's simply, his assertion is that there are people who are involved in crime. If you then can turn to page 28 and look at paragraph 95. So Arthur is the person to whom he owes 11,000 euros or pounds. And if you read 95 and 96, you can see that even on his case, because it's a relatively small debt, it isn't so much the focus of Arthur, it's some other people who, to whom the issue's been delegated. Page 29, 104, he's asked, were you ever hurt physically by Arthur? And he says, not kind of punched or anything, but they'd ask me to get in the car, grab me by my throat and say, why haven't you paid the money back? If you can go to 32, please.
Just pausing there, Arthur's got nothing to do with trafficking,
No.
has he? Arthur's just a
No.
domestic gangster.
Absolutely, and that's a point I'm going to make because he. No. But you're entirely right. So the focus here is on re-trafficking, but just for completeness.
Yeah, sure. Okay.
No, absolutely. Okay. Could I ask you then to turn to 32, please? And you should have. And if you look at 124, this, if you could just read this paragraph yourself, because what it says is that although he says he had a gambling addiction which caused the difficulties in Albania, whilst in custody he has received very valuable treatment and assistance, which has put him in a much better place. So in terms of like any sort of vulnerabilities, potential otherwise arising from effectively the condition that may be said to have put him in this position, it appears that he's received support and benefit which has addressed those issues. And then 125, how would you describe your relationship with Arben at the time you left? Normal rapport, simply with someone who had an office offering jobs abroad. 33, page 33, if you look at paragraph 128, he says, at what point did your relationship with Arben go sour? And then he says, after I got to Holland, I don't know if these people were dealing directly with Arben or not, or affiliated to him. They were saying they were talking to Arben, but I don't really know if they did so at the time. And then paragraph 130, you're asked, how do you know if you owe money to Arben specifically, or to the people already in the UK who brought you here and put you in the cannabis house? And he says, because I've met Alban, and then in Holland I met another Albanian who brought me over to UK from Holland. And then in terms of 132 and 133, he was told that if I stayed at the house from the end of August until 31st of December, the amount would have been paid. And then he says I was actually in the house until the beginning of December. Now, can I hand up one document at this stage? I'm sorry, it should have been in the bundle, so bearing in mind the criticisms that have already legitimately been made, can I apologise for this as well?
Ms. Lawton and Mr. Lanky have this, do they?
It's the sentencing remark.
Yes, I have been provided with it. I haven't been asked if we object.
Oh, a big one.
So
No, well, it's a document, my
Tell us
lord.
what it is first.
Yeah, it's the sentencing remarks from the judge when the respondent was given his 16-month sentence. It's referred to in the Upper Tribunal's decision, so it was obviously before the Upper Tribunal, and it should have been included in the bundle as material before the Upper Tribunal.
Yes, Ms. Lawton.
so I did not appear below, but I have been informed that it was not before the Upper Tribunal. There is reference to the sentencing remarks in the conclusive ground minute, which is from where we can see the reference, but the document itself was not before the Upper Tribunal. I'm not going to make an issue of it.
Let's take the normal course, shall we? I mean, these sorts of things are conventionally in a bundle of this kind. What we'll do is we'll look at it and then we'll see what we think about the point and whether we should formally admit it or not, or whether we actually need to make a decision about it. So should we just move along in that way? Yes. What do we need to look at?
So I apologise. I thought it was before the Upper Tribunal because it's referred to in the judgment. So if you could turn to page 3, which is the transcript, and if you could read the 2 paragraphs. The first one starts, "I have regards," and then the next paragraph, which starts, "unusually."
Yes.
So there are 2 points to be made. First of all, this confirms effectively what's said in the decision letter in terms of the education, the level of education of the respondent, including the fact that his English is very good. And the second point is that what the judge says in terms of the sentence is that the second paragraph, that he finds that the respondent had some awareness of the scale and also a limited role under direction and an element of exploitation. But despite those factors, he nevertheless puts it effectively in the medium category. There's obviously no modern slavery defence run in the case, but it's not as the court is not and does not say that it's right at the bottom end. It's somewhere in the middle in terms of which is then reflected in the sentence.
He was interviewed with an interpreter.
Yes.
In fact, although his English is good, he had the benefit of an interpreter during the interview that you just read to us.
Yes. So that's all really I wanted to say in terms of the first head, under the first heading. Can I then move on to the law and start with sufficiency of protection and ask you to turn to Horvath, which is at tab 5.
Just pausing there 1 second. There's a witness statement that's also in the supplemental bundle, which sets out the respondent sets out its fear of return. That came in as part of the JR, so that was a witness statement prepared at that stage.
I think it was actually prepared before.
But was it before the
For the
Secretary of State?
interview.
Is what I'm asking.
Yes, it
The
was.
Secretary of State had that witness
Yeah.
statement, and so
That's right.
understood the whole thing.
Yeah. Yes, and it's the so the statement is dated February 2024, whereas the interview is
15th of
April
February.
Thank you.
April 2024. And I don't, as far as I can see, there were no sort of discrepancies between the two.
No, only that. I mean, I'm not trying to take clever points at all, I promise. But I just did notice that 36 to 38 of the witness statement talks about fear of being trafficked again if he goes back to Albania. That's, I mean, as I took it, that's really his case. is
Yes,
that
that's
I'm worried that if I go back, I
That's
will
right.
be trafficked again.
That's right.
Or killed.
Okay.
And there's also in the statement there's reference to
Yes.
not being able to access the police
Yes.
because they are
You need money to pay them.
you need
They're
money
corrupt.
to pay. So it's the sort of same point he was making in the interview. So if I can ask you then to turn to Horvath at tab 5. So this is a case that concerned a Roma citizen from Slovakia who was claiming fear of persecution from Slovakian skinheads. So, and in this case, it was accepted that he had a genuine fear of persecution from the skinheads or harm, and the issue was sufficiency of protection in that context. So if I can ask you to turn firstly to page 499, on page 40 in the bundle, and letter G. Can I ask you to read that paragraph, please?
Sorry, which page?
Page 40 in the authorities bundle.
Oh, that's page 40. Okay, sorry.
And then could I ask you to read page 41 from the letter F to the bottom of the page? So now, before I make, could you then turn to page 48, please, and read the paragraph starting at letter D.
Letter D.
My lord, yes. So the 3 points I'd invite you to draw from these paragraphs is firstly, the risk, however severe and however well founded, is only one limb, and the question that then arises relates to the extent to which the state provides protection. Second point is that the state is not expected to or required to achieve complete protection against, but rather having regards to as well the resources available, a appropriate level of protection. And the third point, which is really highlighted at 48, is that where there is a general sufficiency of protection, there won't be many cases where an unwillingness to access it or avail himself will succeed. Here, the applicant's case, as it appears from his written statement, is that he regards the local police as ineffective and indifferent. But he's not the sole judge of that. The test is objective. And I wanted, against that backdrop, to invite you to look at 52, page 52, and read from the letters A to C, where Lord Clyde endorsing the formulation of Lord Justice Stewart in the Court of Appeal judgment in Horvath.
Sorry, where on the page?
It's from letter A, from the top of the page, down to letter D. And the sentence I would invite you to underline from my perspective is between C and D. It will require cogent evidence that the state which is able to afford protection is unwilling to do so, especially in the case of a democracy. So, unless there are any questions, those are the submissions I wanted to make in relation to sufficiency of protection in Horvath. Can I then just, well, I won't take you to this, but there's a case, Bagdana-Vicious, which is in tab 7, and it effectively confirms that the same approach is taken in relation to Article 3. I don't think that's in dispute. Can I then move on to internal relocation? Can I ask you to turn to tab 7, AH Sudan. This involved 3 claimants from Darfur facing risk of persecution in Darfur, and the issue being whether they could, whether it would be unduly harsh to expect them to relocate from a stable rural village life to a camp or squatter settlement in the city of Khartoum. It's a short judgment, and effectively at 76, paragraph 5, Lord Bingham reiterates and quotes from his previous judgment in Januzzi on the same issue. So if I could just ask you to read from C to F. So moving now on to certification, can I ask you to turn to tab 9. Oh, hang on. Sorry, big one. I've got the wrong tab. Tab 8, sorry. And this is ZT Kosovo, and this case involved the issue of whether there was a difference between the test applicable to fresh claims, paragraph 353, or the test applicable to certification decisions. And effectively in looking at this, the approach to certification decisions, certifying what was considered in some detail. And if you can turn to page 96, you have Lord Phillips setting out the approach in paragraph 22. And it's then summarised if you look at paragraph 23. Now, Lord Hope, Lord Carswell, and Lord Newberger, with Lord Hope being the most emphatic, consider that there could be more than one outcome in an assessment of in a certification assessment. So just for those reasons, if you turn to 107 and read paragraph 55, as I said, Lord Hope is effectively the lead judge on this issue.
Page.
Big 107.
Can you help me with quite where we are? Because one of my questions was whether we are looking at the Secretary of State's decision and deciding for ourselves whether we think that that it was the claim was clearly unfounded, or whether we are answering the question which seems to be pleaded in the JR, which was whether the Secretary of State's decision to certify was rational or not.
It's not a straightforward, I'm afraid, answer to this because as I'll show you in the next case, the Supreme Court confirms that it's a review. It's still under sort of public law principles, but then goes on to say that effectively there's only one right answer. So when you put those two together, they're sort of a bit inconsistent, because if there's only one right answer which the court identifies, then the reasonableness of the assessment made by the Secretary of State
comes to the same thing.
Yeah.
But it does matter, doesn't it? So if it's a review, that circumscribes to some extent the approach that the court or the Upper Tribunal takes. It's a review looking for an error of law or an irrationality or something like that. And if it finds it, then it's a binary thing. But it's not a case where the reviewing court goes back to the beginning and builds up as it would if it was a primary decision maker.
No, and I think that must be right, my lord. But can I take you to the next case? Because I struggle with this, because it's repeatedly affirmed that it is like an ordinary Wednesbury review, so anxious scrutiny because of the nature of what we're looking at. But then the water gets muddied by the suggestion that really it's for the court. There's only one answer, and it's for the court to decide that. If I take you, because
yes.
as I said, because
you say that ZT is and indeed Riel and Rasgar as well there's more which you're about to show us before we try to grapple with this if we need to.
Yes, my lord.
Right. So what's the next one?
So my lord, if you don't mind, could I just finish with ZT?
Yes, certainly.
So I'd ask you, I invite you to read 55, paragraph 55.
Yes.
Yeah. And just for your note, 65 is Lord Carswell agreeing with Lord Hope on that point. And then you have Lord Newberger agreeing with Lord Hope, but in more tentative terms at 88. Now, Lord Brown agrees in very emphatic terms, so maybe it'd be worth having a look at that. It agrees with Lord Phillips that there's only one answer. So if you could read 75 and 76. And you see, that needs to be read in conjunction with paragraph 23, which I took you to earlier, where Lord Phillips says, it follows that a challenge to the Secretary of State's conclusion that a claim is clearly unfounded is a rationality challenge. There is no way that a court can consider whether her... Big one, I've gone back to 23 because it's page 97, because that's the sort of foundation of what Lord Brown is agreeing with. And it's the sort of first stage, my lady, in seeking to address your question. So it says there is no way that a court can consider whether her conclusion is rational other than by asking itself the same questions that the Secretary of State has considered. If the court concludes that the claim has a realistic prospect of success, and the Secretary has reached a contrary view, the court will necessarily conclude that the Secretary's view was irrational. If I could then ask you to turn to tab 16, it's a case I will refer you to under two different headings, but for this purpose, certification. Can you?
I'm so sorry.
Yes.
Give the reference again, please.
A big one. Tab 16.
FR.
My lord, yes. And then you could turn to 390, please. So the reason I'm taking you to this case is twofold. If you look at paragraph 45 at the bottom of 390, you will see that things have moved on a little bit since ZT, and now there's a provision in 94 which effectively says a list. If you're going to one of a particular list of states, it's deemed to be safe, and Albania is one of those states.
That was not a piece of legislation on the statute books at this time of ZT.
That's correct.
When did Albania join the list, or when was the list started?
I'll have to come back to you on that, my lord, but this judgment is dated 2016, so a long time before this case, but I will come back to you on that, if I may. And then, please can you read 47? And as you will see from the following paragraphs that I take you to, effectively the Parliament's view on as to the assumption effectively on the listed states being generally safe just seems to be marginalised and have no real impact on what is said to be the court's the approach that you said the court should take, and that analysis starts at page 392, paragraph 52. And there's a reference there to R. Ellen another, and then 2 lines from the bottom there's Lord Phillips stated, and if I could ask you to read to the end of that paragraph. And then,
I'm sorry, I just want to pause on the
sorry,
question that arose a moment ago. Going back to 46, Lord Justice Beatson refers to section 94 as replacing something in the 1999 Act, and it, starting at 44, effect from 20th of October 2014. But the earlier decisions, for example, L in 2003, there was a list, but I'm not up to speed with the development of legislation.
to be honest, my lord, would you mind if I provided you a list of how it developed?
Yes, I mean, it just at some stage, if it matters, it only matters for present purposes, so we can understand whether anything that was said in the earlier cases was said in the context where there wasn't a list.
Oh yes,
which, as it were, reversed the
yes.
burden.
When I say this though, that in terms of the cases that I've taken you to so far, they are on any view not on the list where they weren't. But anyhow, let me provide you what you asked for, my lord, and I will.
Right.
So going back to 392, page 392, I'm taking I think to 52, and then I think the key paragraph then is 54.
So all this is a summary of the 2003 case.
It is, my
which
lord.
preceded the ZT decision.
It is, but then we will go on to ZT here. But see, ZT's case wasn't a case about where there was a country listed under 94. So ZT considers just general certification. This case in L considers certification in the context of a listed country. And then at 56, the court confirms that normal principles of judicial review should be applied. Anxious scrutiny required where human rights are an issue. But because the test is a black and white test, the answer could not, for instance, depend on the burden of proof.
But the observation at the end, although section 94 makes express provision in relation to burden of proof, that's Lord Justice Beatson's observation, is it?
Yeah. And then
If the answer doesn't depend upon the burden of proof, what's the point of having a subsection and a list?
Well, that's that's the point I sought to make less elegant. I was saying it just seems to be wholly marginalised by this judgment. I mean, you've got it. Parliament's view that it's a safe country, generally safe country, but this judgment suggests that very little weight should be attached to that.
I'm sure you're right if you say it's Parliament's view that it's a safe country, but that's a dangerous shorthand. May not be a safe country for the individual in the case.
Absolutely.
The whole point is that you have to look at the situation of the individual in the case.
Absolutely, Mark. So it was dangerous short, because what I meant to say was generally short, and that was from what I referred you to in paragraph 52, which stated that. I was going to just take you to 62, which is the conclusion on this issue.
62.
My lady, yes. And I would emphasise the recognition of the important function given to the Secretary of State for the screening and gatekeeping function. That needs to be recognised in when approaching and scrutinising the decisions taken by the Secretary of State.
Okay, but what is meant in this circumstance by the gatekeeping function?
Well, the purpose of certification was to enable the Secretary of State to weed out cases that have no merit, and so be able to effectively progress immigration control by removal without time and resources being taken up in country.
Well, that I understand. What I don't understand is the word gatekeeping.
Well, I think what's meant by gatekeeping or screening is that because the Secretary of State's decision prevents a right of appeal, it's undertaking a sort of gatekeeping function in terms of deciding whether an appeal can be brought. That's certainly the way I understand.
Does the word? I'm very sorry, but does the word gatekeeping add anything at all? We can see what the statute says. It gives the Secretary of State the power to certify on certain criteria. We know that if an appeal is certified, or an application is certified, then that precludes a further right of appeal. What does gatekeeping add to any of this?
Well, it's just the threshold to be applied. So I was going to take you to a paragraph where the appellant in that case effectively said, well, look, whatever is said, you have to accept it at face value in order to...
I think that, as I understand the answer to my Lord's point, is that gatekeeping or screening is just a descriptive term. It adds nothing to the substance of it, but just the fact is that Parliament has given the Secretary of State the power to identify or triage certain cases that don't get a right of appeal.
But I would go slightly further than that, my Lord, and I would say what is being recognised is that the court mustn't adopt an approach that effectively precludes that function being exercised. And so, for example, in terms of the submission that was made that you have to effectively accept at face value everything anybody says, the Court of Appeal recognised that was an incorrect approach to take when you're looking at whether a case could, on any legitimate view, succeed. So, paragraph 77, the point is made, and my submission is that paragraph and that approach reflects the fact that there needs to, that the function, the Secretary of State's function needs to be considered by reference to or permitting the ability to discharge that function. Because otherwise, effectively, you could have someone saying, anybody saying, I'm at risk of being in America or whatever, and if you had to accept that at face value.
But isn't the point made in the last sentence of para 77, that would be wrong, not as a matter of approach, but as a matter of law, because the test is whether the fear is objectively well founded. So the fact that you have an individual who comes along and says, I have a subjective fear, is never going to be enough to get you home on a refugee claim.
Absolutely, but there is sometimes a tendency to approach certification cases on the basis that since you've got to take the case at its highest, that extends to what Erin said. And so what I was trying to show was this is needed in order to enable the gatekeeping
So are the
function to
golden
be discharged.
paragraphs that I hang on to, we hang on to, it's quite fiddly this, isn't it? Paragraph 62 tells you this is a supervisory jurisdiction, although the court has to apply very intensive review because of the consequences of its decision making. Married with paragraph 77, that although the review is intensive, it's not enough for an appellant or an individual simply to assert a fear. You still have to, I don't know quite how you put it, but you put it in paragraph 77 terms and say what you're asking yourself is whether taking the case at its highest, there is some basis for believing there might be an objectively well-founded fear of persecution, something along those lines.
My lady, yes, if I were you, I would 56, 62 and 77, I would say. Can I just slightly develop in terms of 77, because I think 77 goes a bit wider than the genuine and the objective subjective fear. I mean, an obvious example. So if obviously these are extremes to make the point, but if you were to say I'm terrified because I will be attacked in Notre Dame and you're being returned to Egypt, you are entitled, the Secretary is entitled to take into account objective evidence and say something that's said is undoubtedly incorrect or clearly incorrect.
Right. Well, in the end, we have to. I mean, we need to look at these. These are not primary legislation, and we're going to take a general overview of what previous courts have said about these matters, not treat individual sentences as if they were fundamental tests.
Fair enough. Can I just ask you just to bear with me for one more paragraph?
No, this is very helpful, as it were, but I'm just confirming that the answer is not to be found in a single sentence of any of these decisions, however eminent.
No, absolutely, and I wasn't suggesting, it was really just to provide some context. Just in terms of the point I'd made with the not very good example about Notre Dame, could I ask you just to look at 74, because I think that it might be made better. Or it might be made better.
What, 74 of FR again?
Yes, my lord, 398.
Thank you.
Yes.
No, just a moment. So effectively, where there's no dispute of fact, the point that's made is where there's no dispute of fact, there is only one right answer, and it's in that context that the Wednesbury review must proceed. So, can I turn to my next third heading, which is TDT and the Albanian case law. So, can I ask you to turn to TDT first? Now, The case of TDT concerned a Vietnamese national who had been brought into the UK against his will and who worked on a cannabis farm and managed to escape. And the issue was in the context of the Article 4, the extent.
The reference, please.
Yes, madam. Sorry, it's tab 18, page 437 is the assignment. And the issue was because there's the NRM, so there's ECAT and then there's the Human Rights Act. ECAT is the I don't know, I use that word so often I can't remember what it is. It's the Trafficking Convention.
European Convention Against Trafficking.
Yeah, European Convention Against Trafficking, and that is implemented in the UK via a process called the NRM process, and then sitting alongside that is Article 4, which is what we're concerned with primarily in this case. And the issue in that case related to the when the obligation on the Secretary of State to provide protective steps arose in the context of an individual such as TDT, who was effectively who was found in the UK having been trafficked. So if you can turn to page 449, and if you could read 31 and 31.1 to yourself, you'll. This explains the distinction between the Anti-Trafficking Convention and Article 4. And then if you turn to 451, you have a heading, credible suspicion. And if I can ask you to read paragraph 38, please. Now it's important to understand what the court was addressing here, because there's a two-stage process in terms of within the UK in terms of investigating and providing support to alleged victims of trafficking. There is the initial stage where all forms of public authorities, the police, other local authorities, where there's a credible suspicion that someone might have been trafficked, they refer it into a body called the Competent Authority. So that's called who issue a reasonable grounds decision if they think there's some substance in it. And then once the reasonable grounds decision has been issued, the individual cannot be removed pending something called a conclusive grounds decision, which is where the competent authority has investigated in depth and decided on the balance of probabilities that the individual is or was a victim of trafficking. So all the comments and which and they're relied on in the Upper Tribunal's judgment, in terms of which I'm going to take you to now, they're all in the context of this initial stage of the process where the obligation to investigate further is triggered. And if you can read the argument was at this stage, if you look at the heading past and history and future risk, the argument was which one needed to be focused on, whether it was just future risk or whether one had to actually always start with the past history. And at H, Lord Justice Underhill records the submission, it is prudent to regard any past victim of trafficking as a potential victim of re-trafficking. and it's important for the duty to be engaged so that an assessment of that risk can be made. So you see, this comment about the importance of treating someone who has been trafficked as a potential victim of re-trafficking is really to trigger the obligation to then investigate as to whether they've been trafficked. And that, if you turn over to 452, is made clear by the two lines at the top of the page. And in that context, in other words, just triggering the need to investigate, in paragraph 40, Lord Justice Underhill says, a victim of trafficking who is encountered on the back of a lorry or found working at a cannabis farm or nail bar will not only have been trafficked in the preceding period, but will also be at real and immediate risk of the trafficking continuing, even if the victim has escaped or has been removed from the immediate control of the traffickers. And of course, that's not the situation we are looking at here, because what we're looking at here is potential risk on return. So in this case, the claimant actually, the initial protection he was given was by reason of being detained. And then after that, for the last 6 months, he went to live with his sister in the UK and suffered no difficulties at all. But the focus in terms of immediate risk and the comments there relate to the immediacy of risk in the UK on discovery of an individual or on referral of an individual for subsequent in-depth investigation. And that point is made, at least implicitly, at the bottom of 41. In order to decide whether a past victim is indeed no longer at real and immediate risk of being trafficked, the authorities will, in any event, have to conduct a careful assessment of the crimes which they contended. So that's my point. You have this initial trigger and then the careful assessment, and no suggestion that in undertaking the careful assessment, you need to approach it on the basis that there's a real immediate risk of re-trafficking merely by the fact of past trafficking. Now, turning to the case of the Albanian case, can I start with tab 15? It's a TD. And it provides guidance in relation to trafficked women in relation to Albania. There isn't a country guidance case relating to trafficked men. Perhaps reflecting the fact that far and away the most significant category in terms of trafficked persons from Albania are women. So if you look at 308 to 310, you will see some paragraphs which are in bold, others which aren't. And the paragraphs which are in bold update the guidance previously given in the case called A and BM, Trafficked Women in Albania, 2010. So read together, those paragraphs, they are effectively the existing country guidance case on trafficked women in Albania. And if I can just take you through a few of the points. So you have paragraph D at 309. It records the Albanian government's made significant efforts to improve trafficking. And then importantly there is in general a Horvath standard sufficient protection, but it will not be effective in every case. And so that is because of a point made by the Upper Tribunal judge. That assessment is made specifically in the context of trafficking victims. And then paragraph E records some of the positive improvements in terms of reception and reintegration. And then importantly it says this: unless the individual has particular vulnerabilities such as physical or mental health issues, the option cannot generally be said to be unreasonable. whether it must be determined on a case-by-case basis. And that is why I took you to the passage in the interview recording the progress the respondent had made in terms of the gambling issues. As you will see when you get to the decision letter, the various criteria which are identified as indicators of risk of retrafficking all count against him. And then he says this at G, retrafficking is a reality. Whether that exists for an individual claimant will turn in part on the factors that led to the initial trafficking and on her personal circumstances, including her background, age, willingness and ability to seek help from authorities. For a proportion of victims of trafficking, their situation may mean that they are especially vulnerable to re-trafficking or being forced into other exploitative situations. Whether they're, paragraph H, whether they are at risk of persecution includes, and then it sets out a number of criteria which are relevant to assessing that. And you'll see that there are factors such as level of education, economic standing of the family, state of health, area of origin, age, and what support network will be available. If I can then take you back to FR Albania, which is at tab 16. So this was a case involving two appellants. One is referred to as KL, and KL, if you look at 383, his claim was based on a well-founded fear from the family of AB due to a blood feud. The 2 points I wanted you to focus on in relation to this page is the fact that he produced some objective evidence to support what he was saying. So paragraph 13, the last sentence refers to the hospital letter, sort of confirming one aspect of what he was saying, or supporting one aspect of what he was saying. And then paragraph 15, again, evidence in the form of a judgment suggesting or supporting his claim relating to his father's conviction and sentence for the events that form part of the claim. And you'll see just a few lines down that there's also an assertion that the family was very powerful politically at that time. FR's claim is a claim that's a mix of serious domestic abuse and again blood feud. So you have the husband having threatened to kill her and indeed being very violent physically and sexually towards FR in front of the children. And then you've got a husband, so that's paragraph 17, page 384. Paragraph 18, you've got a husband assaulting a man while drunk, badly injuring them and triggering a blood feud. Now, I've taken you through the certification case law, so moving on to the assessment by reference to the situation in Albania. If I can ask you to turn to 401. You have at 84 a reference to the judgment I've just taken you to, TD and AD, but it's 85 I want to ask you to read, which refers to TD. So the significance of the summary in 85 is twofold. One, it's referred to and applied by the Court of Appeal in the context of not only a female but a male, because KL is male, FR is female. So insofar as there's any suggestion that the analysis in TD should only apply to trafficked women, we would say that that's incorrect. In fact, would make no sense logically in any event. The second point is that there is the starting point, because there is no case after that that suggests that the standard has in some way dropped or is no longer met. There is a Horvath standard sufficiency protection in general in Albania. That's the starting point. And then I just wanted to, and I appreciate that my lord, you may well say to me each case is fact specific, but may I just take you through these just as examples of why the Secretary of State was held to have erred in these cases. 89 makes the point that much of KL's account lacks detail, and his witness statement is no doubt, as Miss Anderson described it, self-serving. But it does appear from the documents, and that's the key point I wanted to stress, was that you've got a self-serving account or vague account, but bolstered by some documentary evidence. And that is sort of key to the initial stage of the conclusion as to why the Secretary's decision was flawed. 90 and 91 deals with sufficiency of protection, and I don't need really to trouble with you 90, because if you look at 91, the difficulty from the Secretary of State in terms of relying on sufficiency of protection is that on the Secretary's own evidence there wasn't sufficiency of protection in the area where the appellant came from. So there you had an objective reason why sufficiency of protection wasn't available. And then in terms of relocation, against the backdrop of the errors already found, the paragraph 93 refers to what the Upper Tribunal judge held, that without family or power, without further explanation, did not give rise to an inference that had a reach extending throughout.
Where are you reading from?
Big one, that's 93, page 403. And the Court of Appeal disagreed with that, but again, by reference to the documentary evidence that had been provided in support. And it's 95, 4 lines down. I do not consider that it can be said that a tribunal properly directing itself could not infer from what KL said about the connection of the B's family to the Democratic Party and to the judge who tried his father that they had a reach throughout Albania. In terms of FR's case, page 405, paragraph 102, you have an example of what we say you find in this case. You have a subjective assertion made, and the
Sorry, I've lost my bearings again.
page 405, paragraph 102.
Thank you.
And so you have a subjective assertion, lack of details, and the Secretary would have been was entitled to conclude that that was clearly unfounded. If you then turn to 406, the case seems to have proceeded on the basis that there wasn't sufficiency of protection for abused women. And so the issue the court went on to consider relocation. That's at paragraph 108, page 406. And if you can read from 3 lines from the bottom, but if FR is relocated, so again, you have the assertion that she can be relocated, but no evidence. And so the issue, if you then turn to look at 109, is about whether it's unduly harsh. And in that case, I don't have to take you through it, but the court held it was unduly harsh because of the mental health issues and children and impact on the children. Sorry, not that it was unduly harsh, it was arguably unduly harsh. It couldn't be said that it would be found to fail. So here you have an example both of the approach to Albania in terms of general sufficiency of protection, and you then with a focus then on whether there is something beyond subjective allegations, and there is something that provides some sort of foundation for any alleged inability or unwillingness to access sufficiency protection. If I can then ask you to turn to SD Albania, which is tab 19. This is a 2019 case. And it relates to, if you look at paragraph 3 of page 470, quite a similar point made of in terms of accumulating. Page 3, page 470. Sorry, paragraph 3, page 470, tab 18. And then, if you can then turn to page 474, the point is made at paragraph 24 by reference to paragraph 77 in FR Albania, which I've already taken you to. Taking a case as highest does not mean everything the appellant claims must be taken as correct. In the paragraph 25 underneath, the court provides a sort of another way or an alternative description of how to approach certification cases. Paragraph 26 then provides another example of where a speculative allegation is actually entitled to reject on the basis that it is speculative. The problem for the Secretary of State in this case then arose in paragraph 27, is recorded in paragraph 27, was that everyone had failed to spot assertions made by the appellant, and you'll recall that in terms of the events which are relied on, they are taken at the highest. This was proceeding on the basis that the appellant had been raped or harmed by and had been told that they would take her children away. So that and on that basis, the court held that the decisions were flawed. But interestingly, and something I would invite you to focus on for the purposes of Upper Tribunal's case, paragraph 31, page 475. The appellant, she said she did not go to police because you can bribe anyone in Albania. This would not have been sufficient to avail the appellant of a ground of appeal. And you can see, we would say that the sort of nebulous subjective assertions made by this appellant, sorry, this respondent, fall within squarely that category. Last case is the case of AD Sweden and others versus Sweden. It's a Strasbourg case. It's a tab 20. It's relatively recent, 7th of May 2024. So to that extent, helpful in understanding the position in Albania. It involved, and I think all I can do really is ask you to read paragraph 7, page 480, because it involved somebody who had been targeted by criminal gangs who had undertaken very serious criminal acts against him and his family.
Paragraph 7.
My lord, yes, 480.
Thank you.
And against that backdrop, this is the Swedish first instance decision. If you look at paragraph 14, page 481, and it's made clear later on, but this assessment is undertaken by reference to everything that the applicants have said was true. Yeah, so this assessment is undertaken by reference to what is asserted to have happened in paragraph 7 did happen. But nevertheless, on the basis that the Albanian authorities had a general ability, willingness to protect their citizens, the application was rejected. Page 483, I won't take you through this in any detail, but there's effectively a fresh claim, and which then relies on additional incidents of of criminal actions against them, very serious criminal actions. But the Swedish authorities maintain the same decision based on sufficiency protection. Page 486 to 493. This sets out extracts from various sources concerning the position in Albania. And can I take you to just a few passages within those extracts? So this is page 488. It's the Swedish Migration Agency, effectively CPIN, and paragraph 41, and then 2 paragraphs. So it starts with the citation, among other things, organised crimes, blood feuds and gang crimes are highlighted as specific problem area by sources. The phenomena are not said to affect the public. Murder and violence are kept within and between networks. And then if you could read the next paragraph starting organised crime. And then if you could turn to 489, and just above the letter D, there's a paragraph which starts in summary. And it's just the first 2 sentences that I wish to highlight. If I can then ask you to turn to 490, you get the information from the Belgian authorities. And if you go to 491, the second paragraph cited starts, Albania has also been taken. Can I ask you to read that paragraph, please?
Sorry, where?
So it's 491, my lord. The second paragraph starting, Albania has also been taken in issue. And the paragraph, can I actually read the first 5 lines of the next paragraph? So there you have, we would say, and the court recognises it in this way at a later stage in the judgment, the consistent evidence is that there is a general sufficiency of protection, a police force that is willing and effective in terms of operating, in terms of and taking steps to deal with criminal actions, including in the sphere of drug trafficking. Now, if I could then ask you to turn to page 495, just to make good the point I made earlier about Article 3, because this case obviously is about Article 3. If you look at 59, there's the second sentence starting, however, it must be shown that the risk is real and that the authorities of the receiving state are not able to obviate the risk by providing appropriate protection. Paragraph 60 makes the point that it's in principle for the applicant to produce evidence capable of proving there are substantial grounds for believing that you'd be exposed to real risk of being subject to treatment contrary to Article 3. And although I haven't taken you to it, treatment contrary to Article 3 isn't referring to just the ill treatment suffered at the hands of an individual. It needs to be either ill treatment undertaken by the state or ill treatment which the state doesn't provide protection against. And then 496, paragraph 61. Relates to the ability of the authorities to protect protection. At 497, because of a point I'll take later, for the sake of transparency, paragraph 66. The court reiterates that the fact of past ill treatment can provide a strong indication of a future real risk of treatment contrary to Article 3. Paragraph 67 makes the point that I made earlier, that the court's going to proceed on the assumption that the applicants in that case faced the ill treatment they'd identified, or risk of ill treatment they'd identified previously, so 67, 68. And then can you read 69, please, and 70 to yourselves, please?
Yes.
And so, against that backdrop, the conclusion at 71 although it's a double negative, is effectively there is general sufficiency protection. The point I'd like to emphasise, because I suspect you may be taken through considerable evidence about corruption, is if you turn back to 497, and you look at 5 lines from the bottom, 6 lines from the bottom, it says essentially from all the reports quoted from the above dating from 200,000 to 2023, it appears that corruption continues to be a widespread problem. So the conclusion on general sufficiency of protection does reflect an assessment of the difficulty, the continuing difficulty in terms of corruption. And then 17.5 and 76 is the decision on the facts of the case, which are a slightly different issue, because in that case the applicants had made some complaints to the police and listed at least some of the issues, and really what the court held was that there was no indication that there'd been a failure by the police in terms of dealing with it. And at 76, any failure to arrest might be for a whole host of different reasons. And noted as well at 77 that the submissions that reporting the crimes would aggravate the situation hasn't been substantiated. And against that backdrop, at 78, no reason to depart from the domestic authorities' assessment that it has not been demonstrated the Albanian authorities are unable or unwilling to obviate any risk of ill treatment by non-state actors, seemingly faced by the applicants by providing appropriate protection. So, again, against that backdrop, can we turn to the decision taken by the Secretary of State? That is at the back of core bundle and starts at 265. Now it's a slightly repetitive decision, so I'll try and make it once only in relation to points that I made, in fact, on a number of occasions. So 265, you have a sort of helpful chronology. So the date that the respondent claimed to have left Albania, July, August 2023. 8th of December is date of arrest.
I think you can take it. We've read this and we follow the chronology.
Could I make one point though? At 266, the fact of the conclusive grounds decision is referred to in the middle of the page. 05 April 2024. So just so there's obviously awareness that the respondent has been accepted as a victim of trafficking. And then the only other point, my lord, was you can see 2nd of August the respondent was granted bail, and after that he resided in the UK, living with his sister without any difficulties from trafficking. And that, of course, is the context in which to consider the reliance on TDT, which really relates to the position in the UK. So, point 267, the reasons for the decision, that just above the basis of the claim, the point's made that his status as a victim of modern slavery, which follows from the conclusive grounds decision, is a separate process, and the consideration below deals with protection issues. So again, there you have confirmation of awareness of the fact that he's been granted or acknowledged as a victim of trafficking. Page 269. The top sentence refers to the correct approach. So, as if the events described had occurred. So not all the assertions made, but the events described occurred. And then at the bottom of the sentence, bottom of the paragraph, correctly refers to the two limbs which need to be met in order to establish a claim of persecution. Protection is not available from the authorities, or that the authorities are unable, unwilling to offer you protection. Additionally, you must demonstrate that there is not another area within Albania to which you could safely relocate. So the test correctly set out for you. The next paragraph under the heading, or paragraphs under the heading assessment of future risk, I accept that while this is obviously relevant context, in terms of certification, it certainly isn't in any way conclusive, and the certification aspect of the letter doesn't say it is in terms of the assessment of future fear. However, in terms of context, the points made at the bottom of the paragraph that the appellant had, and it's phrased in different ways, but effectively the point is made, the appellant hasn't provided evidence as to why Arthur and Arben would have any ongoing motivation to harm him.
Where did you find that?
That's at the bottom of the page, 269, you failed to demonstrate. Well, I appreciate it says demonstrate, but you'll see it's articulated in a different way later on. And then you've got no threats, no contact. And then there's this, if you can turn over at 270. It's also been considered, we've got in the paragraph says, furthermore, you stated you would not be able to relocate within Albania because everyone knows everyone and Albania is small. This does not demonstrate that people you fear have the motivational power to locate you. The next paragraph which, starts, and I've taken you to TD and AD, and it considers the various criteria which you saw in TD as indicative of potential risk of harm. So you had, if you remember, TD and AD generally no real risk of harm, sufficiency of protection, factors which might detract from that, and they're considered here. Then under sufficiency of protection, the points made 3 paragraphs from the bottom. The Albanian authorities are in general willing and able to provide effective protection from non-state actors. Police in Albania have a visible presence throughout Tirana and other large Albanian cities. And then with regards to trafficking, that's addressed at the paragraph below. The fact that corruption is prevalent is referred to and acknowledged in the bottom paragraph. And against that backdrop of objective evidence, page 271, in light of the above, and you have the, we would say, completely correct conclusion, entirely consistent with the case law that I've taken you to, is an established police force from which you could seek protection if a need arose, although they are susceptible to corruption. It must be noted that some corruption, inefficiency and incompetence on the part of individual members of police, prosecution or justice system does not demonstrate a systemic or institutionalized unwillingness to afford protection to the victims of persecution by non-state agents. They refers to Hallbar. And then the next 2 paragraphs deal firstly with Arthur. So Arthur is the loan person who provided the loan, and the points made, well, you never sought protection from him. You don't really know what would have happened. And then the next paragraph, similarly, you failed. This relates to Arben, and the point that's made is, what you said is that you stated you would report the threats, then the next day things would be worse for you. And the point is made, well, this is based on speculation. You haven't previously sought protection, and essentially no detail has been provided to provide a foundation for that assertion. And it's a rather repetitively points made about no contact, and then paragraph below, it's not accepted that they have any influence over the state, or that Albania would be unable or unwilling to offer you protection. The next page 272 relates to relocation, so I'm not going to repeat the same factors that were relied on in terms of sufficiency of protection. But there is a point 4 or 5 paragraphs down that deals with trafficking, which with regards to being a male victim of trafficking. So that's dealt with head on, related to effective safeguards. And then the points are made, have already been made in terms of reasonableness.
What does D&E stand for?
I beg your pardon?
What does D&E stand for in that paragraph? Some sort of state agency.
Can I come back to you on that?
Yeah, sure.
And then the assessment is made that it's reasonable to expect to relocate to another area, such as one of those 3 towns. Vlor's being the biggest one, Berat being the smallest one.
Different and equal.
D&E stands different and equal.
So what is different and equal? The state agency?
Yes.
Sorry, my lady. It's a non-profit organisation providing rehabilitation and reintegration services to victims of trafficking. It's at paragraph 7.1.14 of the hypertext link that you'll see footnoted in that section of the
Very much.
decision.
Thank you.
And then the same factors, education, work, ability to work, are all relied on as to why it's not unduly harsh to expect the respondent to move to another area in Albania. So against that backdrop, if we then turn to the certification decision, and the criticism that's made by the Upper Tribunal can essentially be boiled down to 2 things. It can either the Upper Tribunal is saying that the Secretary of State erred by not repeating the previous reasons under this heading, or the Upper Tribunal is saying you can only really look at what's written in these paragraphs and you need to ignore what's written in the earlier paragraphs. Because each of these statements that are made are underpinned by the analysis that I've taken you through. So, for example, you have not demonstrated or given evidence to support your claim that these people hold any power over or influence over the authorities. That is based on the fact that, having been asked to provide details as to why he considers that he couldn't access or not willing to access the police, beyond saying they're powerful families, he provided no details, and he was given an opportunity to provide details, but he provided no details. So you're just left with no evidence which could provide foundation for a tribunal to conclude that despite the general sufficiency of protection, there isn't in this particular case. And the point is made, which is particularly important because of the need for the fear to be not just subjectively well-founded, but objectively well-founded, is that this assessment is undertaken by reference to the objective information. So the lack of detail in the subjective assertion is considered by reference to the objective information.
Where's that?
It's the bottom sentence, 2nd paragraph from the bottom. As outlined above, so it starts, you have failed to demonstrate these people have a motivation. And then it says 2 lines on, as outlined above, there is sufficient protection within Albania for people in similar situations to yourself. Protection is available to you given the consideration of objective information in the above sections. And the next paragraph deals with relocation. And that again is predicated on the basis that there is nothing beyond a subjective assertion that he may be identified if he moves, because the country is small. And in the paragraph at 281, the correct question is asked, and the correct conclusion is reached by reference to the analysis in the letter considered holistically.
In your skeleton, as I understood it, your submission is really that while taking into account all of the analysis that has gone before, the primary function of the section under certification is addressing trafficking.
Yes.
That's your overarching submission, that although the word trafficking itself doesn't appear at the bottom of page 280 or over to 281, you, as I understand it, submit that this, when one looks at the substance of what is being said here, it's all directed to the risk of trafficking.
It is, Mo. Then I should have perhaps then read the sentence above where it says your fear is based on a moneylender and a man who arranged your travel to the UK.
Yeah.
I mean, that suggests it's both things. It's to do
Yes,
with
both things.
gangsters coming after him for the money he owes. That's Arta.
Yes.
And the re-trafficking issue, because that's the man who arranged travel to the UK. That's Arbon, his.
Yes. Yes, but I agree that they had to look at both of them, but I think as the Upper Tribunal said, the focus is on the trafficking issue, not the Archer, the loan issue. Certainly, when you get to the Upper Tribunal, the only issue that the Upper Tribunal considers is the trafficking issue.
Well, that's because the Upper Tribunal bases its conclusions about the deficiencies of the decision letter on the absence of consideration of trafficking.
Of the fact that it's that the respondent is trafficked.
Yes.
Yeah. And that's why I took you to the passages which record.
I understand that.
Yeah.
But again, what matters is the risk of future trafficking.
It does, but the risk of future trafficking effectively is the risk of harm arising in the context of Article 4.
Yes. Okay. Thank you.
But also, my lord, that's quite correct. But insofar as, because what the certification aspect focuses on is sufficiency, protection, and relocation. So effectively, it's proceeding on the basis that even if there is a risk of re-trafficking, the issue is there sufficient protection? Well, you've given no reasons or provide foundations. Yes. If there is, relocate. Even if there isn't, can you relocate?
I mean, you're facing an argument that the certification decision is, and I'm quoting from paragraph 9 of the skeleton argument written by Miss Lawfully, that it's, quote, extremely brief. What do you say about that?
Well, my lord, I say that there's no obligation on the Secretary of State to repeat the analysis that precedes the paragraph, fully entitled to rely on it, and merely because that analysis is undertaken in the context of refusing the asylum claim, it doesn't in any way.
I may have misunderstood the point that's being made, but there's over a page of this reasoning dealing with the certification decision and its various applications.
Yes, it is, my lord, and the brevity of the reasons in terms of the certification are premised and explained by, in part, the previous reasons that have been given
I
for.
understand that, but I'm querying what appears to be a common position that these reasons are brief, and asking myself what we expect.
Well, And I can.
I mean, this is an extremely long
Less,
decision letter.
it
I'm
is.
not criticising it for that.
But-
Let's have a, I mean, if if your appeal is going to succeed, in my mind at least, it's not going to be because the reasons were too brief.
Well, there was previous criticism by the court, and I can find it for you, about the fact that the Secretary of State's decision letters were effectively didn't deal with, didn't provide any analysis as to why the certification, why a claim was being certified. So if you could turn back to the authorities bundle 385. And you'll see
We're back in FR, are we?
we are, my lord, we are. And if you could read paragraph 27 to 29.
Right, so what's your point?
And the point, my lord, if you look at 29, was that at the time there was just simply a pro forma paragraph at the end. Yep, which dealt with it without any additional reasoning. Now, you can, if you then turn to Lord Justice Davis at 409.
409.
My lord, yes. And he says there's nothing in principle about paragraph 134 objectionable in relying on the reasons that precede it. But then that will necessarily involve close attention to those preceding reasons. So the point I wanted to make, my lord, is there's nothing objectionable in the approach that's been taken, and the Secretary has taken steps to develop the decision making in light of the comments that were made.
But isn't this all subject to the general principle which everybody's familiar with, that you've got to let someone know the reasons why their application has been refused?
Yeah.
And the test, the acid test, is whether taking the decision letter as a whole, it's clear the basis of on which.
Yes.
Does it matter whether it's the section on certification is brief,
no,
or 1 page or 3?
No. That was a bit long-winded way, a bit of a long-winded way to reply, but I just wanted to just establish that this is the sort of the standard process in terms of looking at these cases. It's, Lord Justice David indicates it's not objectionable, but it doesn't mean you're going to have, that the court has to scrutinise all the reasons.
Do I take it that nothing arises on the convention claim aspect of this at all, and all that stuff? Because you focus very much on the protection claim. And
well, I think it stands and falls on the protection claim. I mean, I don't think anyone's, I might be wrong, but I don't think anyone's suggesting that because that wasn't the Upper Tribunal decision either, that there's some medical issue or something like that. Which
it felt to me like that was very much the issue
No.
in the case.
No, I mean, it certainly didn't form any part of the Upper Tribunal decision as far as I can see. Okay. Could I then turn to the Upper Tribunal's decision? And that starts at 81. So, if I can ask you to turn to 93. And if you look at 48, the focus is on the re-trafficking aspect of the claim. And then paragraph 51, you get to the first of, I think there are 7 paragraphs as to why it is said that there are errors in the Secretary of State's assessment. So the first point is that the respondent has limited her consideration, paragraph 51, to her reasons for substantively rejecting the basis of the applicant's claim. And then the point is made, the certificate and the substantive consideration of a claim require different considerations. Now the latter point is correct insofar as it goes. But in terms of the analysis...
I'm sorry to pick you up on something as small as an S, but they require separate consideration. They don't necessarily require different considerations, do they? Or is that referring to the Section 94 test?
Yes, well, I'd understood that to be referring to the different tests.
Okay. Thank you.
So I think what the Upper Tribunal is saying is that, and that's sort of, it's a theme throughout the judgment, that you can, the substantive consideration of the claim, the Secretary is entitled to refuse the claim because it's weak.
But not necessarily sufficient.
But then the Secretary needs to then go on and take an additional step and ask whether it's bound to fail. And I've taken you to the decision letter, and you can see that last paragraph I took you to, that's precisely the question the Secretary of State asked themselves. And as I take you through this, what I think you will notice is that there is hardly any reference at all to any of the reasons given by the Secretary of State in dealing with the evidence on this case. So the point simply made, the first point is that the reliance on the previous reason seems to be of itself, according to the Upper Tribunal, an error. And then when you go to 52...
And that's just plain wrong, you say,
It
isn't
is,
it?
yeah. I mean, it just is. Well, it's wrong in 2 reasons. One is the Secretary did rely on the previous reasons, and 2, the Upper Tribunal erred in not considering those previous reasons and just focusing on the 1 paragraph or 2 paragraphs under the certification heading. If you then look at 52, so it's in particular, so this is linking to the failure to consider the other reasons. In particular, when stating that the applicant has not demonstrated or given evidence to support his claim that these people hold any power or influence over the authorities in Albania which would prevent him from seeking protection, the respondent has failed to take into account the following. So the first point is the applicant has been accepted as a victim of trafficking. So 2 points to be made in relation to that, 3 points actually. One is the letter actually recognises that. 2, the fact that the applicant's been accepted as a victim of trafficking is not relevant in the context of a certification case where the Secretary has to take the case at its highest. So although a lot of emphasis is placed on the acceptance of the applicant as being a victim of trafficking, the reality is, even had the applicant not been accepted for the purposes of the NRM as a victim of trafficking, taking the case at its highest, namely that the applicant says he was taken to Holland, trafficked to the UK, and on the evidence arrested in cannabis. That's the approach the decision maker would have had to take and did take. So there's no magic, or there's nothing added in this case by the fact that the applicant has in fact been accepted in a different system as a victim of trafficking. But in any event, the more important point, and the third point, is just because the applicant has been accepted as a victim of trafficking, why is that in any way relevant to assessing his assertion that the Arben, so not the people who are trafficking from Holland, but Arben, has any power or influence over the authorities? Because what the judge is not saying is that and the Upper Tribunal is not looking at the facts of this case and saying, look, because of these aspects of the trafficking, this indicates that there's some influence. Just simply saying, because as a victim of trafficking, that of itself is indicative of or supports the suggestion, the otherwise subjective suggestion, that Arbon has power or influence over the authorities. Paragraph C, the same point can be made because what is relied on is simply the fact that modern slavery does occur in Albania. Well, I mean, clearly the decision recognised that, or the country guidance recognises there is an issue. Modern slavery occurs in the UK, it occurs in all over the world.
Sorry, what's the answer on B?
I was going to, can I?
Oh, sorry,
so
I
no,
thought we were on that.
No, I'm sorry, I was on C because what the point I was making, I was just relying on or addressing 2 points that are made as sort of general points, but not by reference to the particular facts of this case. Yeah. So one is he's a victim of trafficking. 2 is that modern slavery occurs in Albania. So these are just very general points, not relied on by reference to what happened in this case, just general points about trafficking. And the point I was making in terms of the fact that modern slavery occurs in Albania, that provides no basis at all to suggest that in this case, the subjective views of the appellant as to Arbon's power have any merit.
So does that go back to some of the case law that you showed us that said, yes, there are problems, but overall, it's a reasonably safe place. There are systems.
It does, but it also goes to a different point because what you're looking at in this case is what was happened or was happening what happened to this individual and what this individual says. The fact that there may be, as a generality, some modern slavery in a country doesn't provide support to the individual's assertion that Arbon has influence on the authorities. I mean, there's just no connection. And it's the same in terms of having been a victim of trafficking. That of itself doesn't provide any support for his assertion that Arbon, in particular, has influence over the authorities. And then turning to B, so the point that's made is that a tribunal could rationally find that the fact that the persons who trafficked him had been sufficiently sophisticated in their operations so as to be able to evade the authorities in Albania or ensure that the applicant was not able to seek protection until the police in the UK intervened, that in some way supports the assertion that Arbon had influence over the authorities in Albania. So 2 points. Firstly, whatever happened in the UK has got nothing to do with or gives no indication at all as to Arbon's influence in the authorities in Albania. But the second point is that, dealing with the suggestion of a sophisticated operator, as you've seen on the respondent's case, the whole departure from Albania was nothing unusual about that. All the operational difficulties occurred, whether they refer to sophisticated others, in Holland. And so again, whatever happened in Holland cannot be relied on, or is not relevant, we say, it doesn't provide support for Arbon having significant influence over the authorities in Albania. They're just not linked. And then D is an odd point at multiple levels. The first point is that TDT is relied on as sort of indicating that people sort of returning wherever they are returned to in the world, that there is sort of this presumption that because they've been trafficked, there's a real and immediate risk of being re-trafficked. And I've gone through what I say about that. But the second point is that even if this is correct, this only goes to whether there's a risk. You know, it doesn't go to sufficiency of protection. It doesn't go to relocation. And then the third point, which is sort of woven into this reliance on paragraph 339K, which is a sort of a presumption in the rules that past persecution can be indicative of future persecution. If you remember, I took you to SW Sweden. I took you to the sentence where the court recognised in terms of Article 3 that it's indicative, can be a powerful indicator of future risk of persecution. So the same point can be made. It doesn't go to sufficiency of protection. It just goes to risk of harm. But the other point is that, in contrast to many trafficking cases where the individual who's trafficked is under the control of the gang in the country from where they're trafficked. So if you look at the TD case and the evidence in terms of female victims, that's the primary scenario. This is a very different scenario because you have the MB, you have the respondent, putting himself forward to travel and then having the problems in Holland. And there's no reason to think, and it's not suggested, that MB would do that again, that he would put himself forward, to travel in similar circumstances.
He does say in his witness statement that he thinks he'd have to do that again, but it is just an assertion. It's not. It doesn't give a reason why.
No, I think that I understood that to be sort of wrapped up in the re-trafficking point, because it seemed, but we would submit in any event that that's just a subjective assertion and no basis for considering that it would eventuate. So when you look at the first four reasons that are given for criticising the Secretary of State's decision, none of them have any merit at all. Two are general points, A and B. D, it's not relevant to sufficiency of protection and is wrong. And B, the sophistication of the operation. There's no evidence from the claimant as to the sophistication of the operation in Albania. Comments relate to events, even if they're accepted, well, they are accepted in Holland. So not indicative of the position of the Albanian authority. If we then turn to paragraph 55.
50, how many?
Paragraph 55, my lord, page 96.
Got it.
This is the next criticism. The respondent has failed to ask herself whether or not the applicant's claim that it would not be sufficient protection as a result of his own particular circumstances, which include his vulnerabilities as a victim of trafficking. Now, that's the only aspect of the circumstances that are identified. There's no. I've shown you the decision letter. I've shown you all the criteria that were looked at. The fact that he was well educated, the fact that he had support from his parents, previously worked, all of those points. So his position was considered. So the only vulnerability which is actually identified, which hasn't been considered, he said, is that he's a victim of trafficking. But that was considered because that is referred to on two occasions, the fact that his status. And there are, I can take you back if you don't remember them, but there are two references to, it was the E&D point, which is about it, and there's another one about the protection being provided to traffic victims. So it's completely wrong to say that there was no consideration of that.
I'm puzzled by the last sentence of 55. It's mentioned earlier on in this reasoning, but the point is being made that the Secretary of State didn't add any further reason with reference to the applicable test. It wouldn't on the whole be expected that another reason that hadn't been referred to in the context of the rejection of the substantive claims would then be introduced at the stage of explaining why it was unarguable.
Absolutely, my lord. And I was going to make the similar point, which was that there's nothing that would be relevant to the certification decision,
No,
which
I
would
mean,
be
in fact-
relevant to
In
determining
fact, if you were looking for a public law error, you might very well find it by introducing something to the certification decision
which wasn't
by the side door.
Yeah.
I don't at the moment understand the references in this decision to the Secretary of State only relying on the reasons that she'd already given rather than some other reasons.
Yeah.
I can't quite understand that the issue is about whether the Secretary of State genuinely applied the correct second test to the materials, but we were always going to be looking at the same materials.
Yeah, and to make good, in a sense, to highlight the difficulty in the approach the judge has taken is that when you go through this decision, none of the reasons are actually analysed or referred to. So what the judge says throughout this is general points about trafficked migrants, general points about vulnerabilities, yeah, but doesn't engage with any of the reasoning in the decision letter because the judge has taken the view that none of that falls to be considered. And the point that's made in 55, just before the sentence my lord referred me to, is that the reasons for refusing rely on the fact that there's sufficiency of protection in general, and that the applicant hasn't provided evidence as to the power and influence of the past traffickers. I mean, that's obviously key to the decision because
You say that's right, that's the answer.
that's it. I mean, it's a perfectly reasonable decision to take, and it's correct because it's a subjective assertion without detail. So if you ask yourself, the tribunal judge, and it's limited to this evidence, yeah, limited to what was said in the interview. So, knowing, properly applying the case law about Albania, including AD versus Sweden, there's a general sufficiency of protection. So on what basis could a upper tribunal or could a first tier tribunal conclude that that was displaced in this case? All you have is an assertion that Arban has power and influence. And the individual has been asked, the respondent, well, why? Give us some detail. And no detail is provided.
I don't wish to suggest in any way that the upper tribunal judge didn't grasp fully the issues on which he was engaged, but just looking back at the earlier parts of the decision, if we go back to paragraph 21, section C.
I'm sorry, sorry.
In the UT decision, it's page 86. The judge strictly correctly focuses on the certification decision as being the impugned decision, and then she sets it out in full. I'm looking for where she sets out the whole rest of the decision, into which the certification decision is sitting. I mean, I'm just trying to evaluate your point. I'm not expressing an opinion about it, but essentially your point is that it doesn't do to simply pluck out the certification decision. One would expect if the judge was going to quash the certification decision, that she had actually, one would expect to see a passage in the judgment in which there was a full analysis of the underlying decision, which then led to the certification. Is that the point that you're
My lord, yes,
making?
yes. So one would expect there to be a record not only of the certification aspect but the key aspects of the previous decision, sorry, of the asylum context decision.
But I mean, the way in which that might be done, you've said a couple of times that there's no reference to the decision reasons actually given. The way in which one might most plausibly expect to find the judge giving consideration to the reasons actually given would be by summarising what they were at some point in the decision. As one of the, it's a very well structured decision, and one would expect to find, whether it's E, F, or G, what your reasons were for your substantive decision.
Yes.
But that is a gap in this decision.
Absolutely, my lord. And
as you would put it.
I would put it that way, my lord. But even so, that would be, let's say, my primary position. But I would also say, even if that of itself isn't an error, none of the judge's reasons engage with the Secretary.
Right, so it can be taken that the judge knew what your reasons were, but the judgment doesn't give any support for her bringing them into her criticism of your.
Yeah. So it's the first point, as is the primary point, is the point as you articulated, my lord. The secondary is, even if she was aware of the reasons, then she's failed to actually address them or address any of her conclusions by reference to those reasons.
All right. Is there anything else?
There was a little bit. Can I
no, let's do
10 minutes, 5 minutes?
5 minutes now.
Yeah.
Okay, let's keep to that.
Okay. Okay. Can I? So paragraph 56 then makes the same point. Again, the focus is on just the fact of being trafficked per se is enough to suggest power and influence. That's simply irrational. And saying that, nor is it fanciful for the applicant to suggest, and fanciful is a word that's used throughout this judgment, and it elides the credibility of what's said, or is it? Yeah. So in other words, someone can have a subjective and credible, in that sense, assertion, but fails to address the objective elements to it. So the applicant might subjectively say that he can't access protections, mean protection, but that needs to be considered by reference to what he's saying in support of that, i.e. is there a foundation for that, and the objective evidence. And when you look at that, we say no tribunal could legitimately conclude that he's at risk of persecution. Paragraph 58 is slightly ironic because it refers to, it asserts the respondent of failing to look at the reasons where in circumstances where one would say this upper tribunal judge has failed to look at them. 60 is another very bad point. I've taken you to AD and others, and I took you, I think, to the fact that it applies to trafficking, traffic victims. So there's reference to TD, which applies to traffic victims. So the fact that AD and others, just like, that's the Swedish case, sorry, I got myself confused. The fact that AD and others doesn't specifically concern trafficking is irrelevant. It provides an up-to-date confirmation that there is general sufficiency of protection, and there's no reason to think that for some reason, male victims of trafficking are sort of carved out of that process or that sufficiency of protection. 61 is even more difficult to understand because once I took you to Harvard, I've taken you there, and it says precisely that a generally effective legal and criminal justice and enforcement system suffices. So the fact that there are gaps there is totally irrelevant. And then paragraph 63 refers to the fact that on the respondent's own evidence, it cannot be said in my judgment that the applicant's claim that he will not be able to access sufficient protection for reasons that include corruption is a claim that's bound to fail. But those aren't the applicant's reasons. The applicant simply says the family is powerful, Albany is powerful and has influence. But in any event, given the objective evidence and the sufficient protection, it precisely can fail and will fail. Last point is relocation, which I haven't dealt with. So 67 deals with relocation. I will. This is my last 2 minutes, so I will. But I do want to make this point because the relocation analysis is particularly poor. So what the judge says is the applicant's claim, a few lines down in 67, that he could not relocate as a result of the power and influence held by the past traffickers, or as a result of his own particular vulnerabilities and needs. Is it capable of belief? Yes. So there are 3 things wrong by that. With that. Firstly, it's not whether those fears are capable of belief, it's whether objectively they're well founded. Second, he hasn't given any evidence of particular vulnerabilities which would justify concluding that it's unduly harsh. And third, he hasn't said that urban influence extends beyond Tirana. What he said, and I took you to it in the interview record, is he has said Albania is a small country, the towns are small, 100,000 people, and there are criminals in those towns. We might be able to identify them. But even taking its highest, there's no suggestion there that Arben's reach extends to those towns. It's simply an assertion that there are criminals there who might identify them. So, for all those reasons, there is simply no basis at all for challenging the Secretary of State's decision that even if there isn't sufficient protection, any tribunal properly directed in law and considering the proper case, the appropriate case law would conclude that relocation is reasonable. Unless I can be of further assistance, those are my submissions.
Thank you, Mr. Biggs. How long are you going to need on ground 3?
I will take stock, my lord. I had originally slated 30 minutes, but I will do my best to complete my submissions within 15 minutes after lunch because I think we are.
Well, I think that's only fair. 15 minutes maximum at 2:05.
Court rise in April.